This lesson will discuss the Canadian doctrine of adequate alternative remedies. As usual, learning materials on the topic can be found in the description below the video. The doctrine of adequate alternative remedies governs when judicial review may be refused because an alternative, sufficient remedy is available through existing procedures. Its guiding principle is that judicial review should be a last resort, only used after all other prescribed avenues, such as appeals or internal reviews, have been exhausted. For the doctrine to apply, the alternative remedy must be truly available and adequate. Courts assess adequacy based on factors like cost, timeliness, convenience, and whether the alternative forum can effectively cure the alleged defect, such as a denial of procedural fairness. If the issue can be properly addressed and corrected through the alternative mechanism, judicial review will generally not be granted. Even though Section 2(1) of the Judicial Review Procedure Act allows applications for judicial review despite any right of appeal, courts are not obligated to proceed unless exceptional circumstances justify it. In practice, this means courts will typically defer to administrative processes and will only intervene when there is a compelling reason to do so. This approach was affirmed in Volochay v. College of Massage Therapists of Ontario, decided in 2012. In that case, the applicant bypassed a review procedure, the HPARB, and went straight to court, alleging a denial of procedural fairness. The court rejected the judicial review, confirming that procedural fairness concerns alone do not constitute an exceptional circumstance unless the alternate process cannot address the issue adequately. This aligns with the earlier decision in Canada, Border Services Agency, and C.B. Powell Limited, decided in 2010, which reinforced the principle that judicial review should be withheld, where administrative bodies are capable of dealing with the alleged wrong. The doctrine of adequate alternative remedies also reflect a broader judicial commitment to respect the autonomy and authority of administrative bodies. By requiring individuals to complete available internal procedures first, the courts aim to ensure efficiency, conserve judicial resources, and reduce costs and delays. Courts may still deny judicial review even if no alternative remedy exists, under certain procedural or fairness-based grounds, including prematurity. The application is brought before the administrative process is complete, e.g., Air Canada v. Lorenz, decided in 2000. Delay or waiver. If the applicant waits too long, typically more than 6 months to initiate, or more than 12 months to perfect the application, the claim may be denied, e.g., Toronto District School Board v. Third Child and Family Services Review Board, decided in 2019. Mootness. The issue is no longer live or relevant to the applicant, though courts can still hear such cases, e.g. Borowski v. Canada. Applicant misconduct. A party acting in bad faith or engaging in procedural abuse may be barred, e.g. Homex Realty v. Wyoming. Balance of convenience. Courts may consider overall fairness and practicality, particularly in public interest cases, e.g. Mining Watch Canada v. Canada, Fisheries and Oceans. In summary, the doctrine of adequate alternative remedies reinforce the principle that judicial review is not automatic. Instead, individuals must first exhaust all other viable remedies, unless truly exceptional circumstances justify court intervention. This approach balances respect for administrative authority with the need to protect procedural fairness in rare cases where alternatives are insufficient.